Dear all, we start part 2, Basis of the Law of Obligation. Here we start with obligation security means, which we will discuss in more detail. First of all, I will name obligation security means. These are mortgage or pledge. When we speak about pledge, we speak about movable property. When we speak about mortgage, we speak about real estate. Next, it is surety, independent guarantee, forfeit, which is equivalent to liquidated damages, security payment, earnest money, and retaining. What is important about obligation security means that securing obligation follows the main obligation. So let's suppose you take a credit in bank. So you have primary agreement, which is credit agreement. Because when we speak about obligation securities means, for example, mortgage, you will never give your apartment or any other property into mortgage if you do not take credit. So what is important here? That primary obligation is credit obligation and subsidiary obligation, collateral obligation, is securing obligation like mortgage. So the following rules shall apply here. First of all, securing obligation follows the main obligation. What it means? It means if you have paid the credit, mortgage stops. Next, volume of execution may decrease quantity of securing obligation. So if you paid 9/10 of the credit, then your mortgage can be decreased. Non-validity of the main obligation will invalidate securing obligation. Credit agreement invalid, the same follows for securing obligation. It is invalid as well. And opposite situation, non-validity of securing obligation will not invalidate main obligation. And in case of termination of the main obligation, security obligation shall also terminate. So that means that main obligation influences securing obligation, but opposite situation, securing obligation, does not influence main obligation. Let's discuss obligation securities means in more detail. If we speak about pledge, pledge arises either by agreement or under law. So, for example, if you have paid 20% of the price, automatically under law, pledge agreement will arise. Parties to pledge are the following: creator and debtor. So creator is pledgee and debtor is pledger. What can be subject matter of pledge? Subject matter of pledge can be property, securities, money. What cannot be subject matter of pledge? Property which is excluded from business turnover, like drugs or weapons. Claims linked to pledger's personality, like alimentary payments, for example. Or other rights whose alienation is prohibited, so for example, golden share. Golden share is the right of the Russian Federation to participate in public companies limited by shares. So it is prohibited to alienate these rights and they cannot be subject matter of pledge. When pledge agreement is not executed, so when primary contract not executed, when payment not affected by a person, so you haven't paid for what you took from the bank for your credit, then it is possible to put execution on mortgaged property. So when we speak about property, when we speak about pledge, pledge is property security. What it means? It means that you can receive payment from mortgaged property before all other creditors. So the level of mortgaged property secures your obligation. What it means? It means that if property was provided for 5 million rubles and your debt is 1 million rubles, then execution of property from your pledge is quite easy. So property will be sold. First part 1 million rubles plus expenses given to creditor and the rest given back to you. Other situation, if property which you provided is less than this 1 million rubles. What will happen in this case? In this case, part of the property, so for example, property was sold for 200,000 rubles, it is given to creditor, and creditor is still the creditor, so you haven't paid the property, but creditor is the final one from creditors to receive your property. In certain cases, execution on property is put under the court decision. So, for example, consent of other persons has been required for conclusion of the contract. Consent of your spouse, for example. When subject matter of pledge is property of historical value. When pledger is absent. When we speak about living premises who are the only one dwelling of a natural person, or when it is directly provided in pledge contract that court decision is necessary, or when it is not provided that it is possible to put execution on pledged property without your consent. Property is sold at public auction. If we speak about movable property, so when we speak about pledge, open auction starts with 100% of market value, which is assessed by independent appraiser or by court. If we speak about real estate, here the situation is different, because in this situation, starting price is 80% of the market value. A number of outcomes of the auction. One of the outcomes that auction has failed. In this case, repeated auction shall take place. Price decreases in both cases. In case of movable property, decrease starts from 100%. In case of real estate, it starts from 80%. If repeated auction failed as well, so in this case, it is possible for pledgee to obtain the property, in case of real estate, 25% cheaper than it was initial price. And cases of termination of pledge are the following. Termination of the obligation secured by pledge, in case of purchase of pledged property by the person being unaware that the property is the object of pledge, so property was sold. In case of perish of pledged object, in case of sale of the pledged property, in case of recognition of pledge agreement invalid, or under the court decision. Very similar to pledge is the other obligation security means, which is retaining. What is the main difference between pledge and retaining? When we speak about pledge, pledge arises under contract or under law, retaining under actual situation. So when we speak about retaining, in fact, commission agent was not paid and retained property belonging to principal. Another obligation security means, when we speak about not property guarantee, but personal guarantee, is surety or independent guarantee. Independent guarantee is the only obligation security means which does not depend on the main obligation. Surety depends on the main obligation. That is why surety terminates with termination of the main obligation. But if we speak about independent guarantee does not depend on the main obligation and does not terminate with termination of the main obligation. So in case of independent guarantee, it is independent. It is provided from independent entrepreneurs and legal entities. It is substitution of what was before 2015 banking guarantee, but here not only banks participate, but also other institutions, including independent entrepreneurs. Other obligation security means is forfeit. Forfeit can have two forms. So it can be penalty or it can be in stable sum. Security payment is quite new obligation security means when payment is provided. So for example, you rent certain property and provide for final month security payment. And if we speak about earnest money, so the case of earnest money is quite interesting because in case of earnest money, there is guarantee, additional guarantee to other participants. So first of all, if we compare security payment and earnest money, they have similar functions: payment function, security function, ascertaining function, and compensation. But what happens in case of earnest money or in case of security payment if main obligation is not executed? So, for example, we have parties A and B. You paid 1 million rubles as securities payment for, let's say, buying an office space which costs 100,000 million rubles, so 1 billion rubles. So what happens in this case? You made securities payment, you found some other premises which are cheaper, and you do not want to execute this obligation. So what you do in this case? This money will be returned to you, but losses which the other party has incurred can be taken from you. What happens in case your payment is named earnest money? Money is retained with injured party, plus injured party may claim losses. Another situation. So you made the payment, but party B does not want to execute obligations. 1 million is returned back to you and you claim losses. What happens in case of earnest money? The other party must return back to you 2 million rubles. So that means double sum of earnest money plus still you're entitled to losses.